Welcome to our video on the recent lawsuits against Stability AI, the creators of the viral AI art tool Stable Diffusion. This past week, we've witnessed two major legal actions being taken against the company, one by a group of 3 talented artists and the other by none other than Getty Images. In this video, we'll be diving deep into the juicy details of these cases, as well as the heated debate in the art community about the use of AI in art and the burning questions it raises about the use of AI. First up, let's take a look at the lawsuit filed by a group of 3 artists, Sarah Anderson, Kelly McKernan, and Carla Ortiz. These artists are accusing Stability AI, along with Midjourney and DeviantArt, of infringing the rights of millions of artists by training their AI tools on 5 billion images scraped from the web without the consent of the original artists. Lawyer and typographer Matthew Butterick, who filed the lawsuit along with the Joseph Saveri law firm, which specializes in antitrust and class action cases, describes the case as a step towards making AI fair and ethical for everyone. The artists argue that the use of AI art generators like Stable Diffusion to create artwork that replicates the style of specific artists without their knowledge or consent will flood the market with an unlimited number of infringing images, which will inflict permanent damage on the market for art and artists. The legal dispute brings to light the ongoing controversy in the art industry surrounding the utilization of artificial intelligence. While some see it as a valuable tool, similar to previous technologies like Photoshop and Illustrator, many artists object to the use of their work to train these profit-generating systems. AI art generators are often trained using a vast amount of images sourced from the internet without the knowledge or permission of the original creators. The developers of AI art tools argue that the training of this software on copyrighted data is protected under the fair use doctrine in the United States. However, fair use still needs to be legally determined, and there are various complexities involved in the case of AI art generators. It's worth mentioning that this lawsuit has received some criticism. Some experts have pointed out that the lawsuit contains technical inaccuracies. For example, it claims that AI art models store compressed copies of copyright-protected training images and then recombine them, functioning as 21st century collage tool. However, AI art models do not actually store images, but rather mathematical representations of patterns collected from them. The software does not piece together bits of images in the form of a collage, but creates new pictures based on these mathematical representations. Additionally, some experts have criticized the lawsuit for its lack of specificity in terms of the particular images or works that are alleged to have been used without consent. This makes it difficult to fully evaluate the merits of the claims being made by the plaintiffs. Before we continue, a small request. Want to support us in creating even better content for you? Hit that subscribe button. It means a lot to us. Now let's take a look at the lawsuit filed by Getty Images. The stock photo company has accused Stability AI of unlawfully copying and processing millions of images protected by copyright to train its software. Getty Images CEO Craig Peters claims that the company has issued Stability AI with a letter before action and has commenced legal proceedings in the High Court of Justice in London against the firm. Peters argues that Stability AI's use of Getty Images' intellectual property to build a commercial offering for their own financial benefit is not covered by fair dealing in the UK or fair use in the US. The CEO of Getty Images, Peters, likens the current legal situation in the generative AI industry to the early days of digital music. He states that companies like Napster provided popular but illegal services before agreements were established with rights holders such as music labels. We think similarly these generative models need to address the intellectual property of rights of others. That's the crux of it, and we're taking this action to get clarity, said Peters in an interview with The Verge. As the legal battle over ownership and profit in the creative industries continues, with AI companies and content creators facing off in court, it becomes increasingly clear that the question of who owns the rights to AI-generated works must be addressed. These lawsuits serve as a reminder of the ethical implications of using AI in art and the importance of ensuring that all parties involved, including artists and content creators, are fairly compensated for their work. However, the Copyright Office in the US has added complexity to this issue by granting registration to a graphic novel created entirely by AI, authored by a human. This raises important questions about the eligibility of AI-generated works for copyright protection and the role of human creativity in the creation of such works. Under copyright law, a work must contain a scintilla of creativity to be eligible for protection. This means that even if a robot is responsible for the majority of the creation, as long as a small amount of creativity is present, it can be protected by copyright. Proponents of AI art argue that there is significant creative work involved in the selection and refinement of the prompts used to generate the art, similar to the process of framing a shot in traditional photography. Another issue is the use of AI to copy an artist's style. For example, if an AI could draw a portrait in the style of Picasso or a landscape in the style of Van Gogh, would that be considered copyright infringement? It would not be considered infringement because the AI, or the human who directed the AI, would not be held liable. As AI technology continues to advance and its use in creating art becomes more prevalent, it is crucial to address these legal issues and have an open and honest conversation about the future of AI in the art world. So, what does this all mean for the future of AI in art? Well, these lawsuits raise important ethical considerations about the use of AI in art. The artists argue that their rights have been infringed by the use of their work without consent, and that the flooding of the markets with an unlimited amount of images created by AI will devalue the work of human artists. Additionally, there is a question of authorship and originality when AI models create works that are similar to human artists. As this debate continues, it's important to remember that AI technology is constantly evolving, and it's crucial that we continue to have open and honest conversations about the future of AI in art. What's your take on copyrights for AI-generated art? Is AI-generated art the future or a threat to human art? Let us know in the comments below, and don't forget to like, share, and subscribe for more content like this. Thanks for watching.